For decades, Congress has been turning over more and more lawmaking power to the executive branch. Frequently, this is done by legislation giving the head of some agency or department the power to establish rules which have the force of law. What happens when the legislation doesn't explicitly say that such and such a department has the power to make a certain rule? To deal with this, courts have come up with something called Chevron Deference. While the case Loper Bright Enterprises v. Gina Raimondo, Secretary of Commerce, deals with who pays the salaries of federal observers on fishing boats, a more fundamental questioning of the court's deference to government agencies' interpretation of law is the cornerstone of the petitioner's argument. So we'll look at that more closely right here on the Constitution Study.
Lovely neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution. Teach your action generation be free. Glad you could join me today. This issue of Chevron and what's called Chevron Deference, well, it's been around since the 80s. And it's something that started out for good and really has turned evil. Now, if you want to learn more about this, I've wrote an article. I have all the links in it. You can find it at the website, constitutionstudy.com. I'll talk more about the website at the end of the episode, but for now, let's take a look at this Chevron Deference and this Loper case. Let's start off with a discussion of what is commonly called Chevron. This precedent comes from the 1984 case Chevron USA versus the National Resources Defense Council, or NRDC. The primary holding of the Chevron case is a government agency must conform to any clear legislative statements when interpreting and applying a law. But courts will give the agency deference in ambiguous situations as long as its interpretation is reasonable. The idea seems simple enough. Government agencies must follow any clear legislative statements when they apply a law. However, if there is an ambiguous situation, the courts will defer to the interpretation of the agency as long as it's reasonable. After all, you cannot expect any man-made organization to be able to predict every possible permutation of every situation. So it makes sense if something in the law is ambiguous, capable of being understood in two or more possible senses or ways, somebody has to decide. And technically, there are three possibilities as to who might do that: the courts, the agency, or Congress. Now, since 1984, the courts have deferred to the agency to make such decisions. As is often the case, though, give an agency an inch, they'll take a mile. Such is true with Loper Bright Enterprises versus Gina Raimondo, Secretary of Commerce. The petitioners, Loper Bright Enterprises et al., were represented at the Supreme Court by Paul D. Clement. He starts his argument with the specifics of the case.
Commercial fishing is hard. Space on board vessels is tight, and margins are tighter still. Therefore, for my clients, having to carry federal observers on board is a burden, but having to pay their salaries is a crippling blow. Congress recognized as much by strictly limiting the circumstances in which domestic fishing vessels could be saddled with monitoring costs and capping them at 2 to 3% of the value of the catch. But the agency here showed no such restraint, requiring monitoring on 50% of the trips at a cost of up to 20% of their annual returns. Nonetheless, the court below deferred to the agency because it viewed the statute as silent on the who pays question.
Congress established by law that domestic fishing vessels had to be monitored to ensure they follow the law. But they didn't specifically say who was to pay for the monitoring. The Department of Commerce decided that since Congress didn't say they couldn't make the fishing vessels pay for the monitor's salary, they had the statutory authority to do so. As you would expect, the petitioners disagreed.
There is no justification for giving the tie to the government or conjuring agency authority from silence. Both the APA and constitutional avoidance principles call for de novo review, asking only what's the best reading of the statute. Asking instead, is the statute ambiguous, is fundamentally misguided. The whole point of statutory construction is to bring clarity, not to identify ambiguity.
Both the Administrative Procedures Act, the APA, and the concept of constitutional avoidance, where federal courts should avoid a constitution-based decision when a statutory or regulatory one is available, state that the court review the case de novo, anew, to determine the best understanding of the law, though that is exactly what the Chevron Deference bypasses.
The government defends this practice not as the best reading of the APA, but by invoking stare decisis. That is doubly problematic. First, at issue here is only Chevron's methodology, which is entitled to reduced stare decisis effect. We have no beef with Chevron's Clean Air Act holding, and we could not take issue with its APA holding because it failed to mention that statute. But second, all the traditional stare decisis factors point in favor of overruling Chevron's methodology. The doctrine is unworkable as its critical threshold question of ambiguity is hopelessly ambiguous. It is also a reliance-destroying doctrine because it facilitates agency flip-flopping. So the reality here is the Chevron two-step has to go and should be replaced with only one question. What is the best reading of the statute?
Representing the government is Solicitor General Elizabeth B. Preligar. Now, she opened her defense with,
throughout this litigation and at times this morning, petitioners have sought to characterize this case as presenting a fundamental question of the separation of powers and a test of Article 3. Will courts continue to say what the law is?
While the belief is commonly held, the purpose of Article 3 courts is not to arbitrarily say what the law is, but to decide controversies based on those laws. Since the specifics of those laws need to be considered when applied to specific cases, there's obviously some interpretation that goes along with the role of a judge. General Preligar then sets up a straw man for the court.
Imagine, for example, if the statute said in Chevron, stationary source as defined by the administrator. I take both petitioners to give that up and recognize that is a delegation and courts should respect that. The role of the court in that circumstance is to make sure that the agency has followed the proper procedures and stayed within whatever outer bounds Congress itself has set. And all of that complies with the Constitution, of course, because Congress has Article 1 authority to delegate gap-filling authority to agencies, and the executive has core Article 2 authority to fill in those gaps.
First, General Preligar attempts to redirect the question at hand. Petitioners are questioning the deference to the agency when Congress is silent, not when they have explicitly delegated authority to an agency. This is based on two fundamental errors by General Preligar. First, nothing in the Constitution delegates to Congress the authority to delegate to another the power to fill in the gaps in their legislation. Second, neither does the Constitution delegate to the executive branch the authority to fill those gaps. Still, there's a more fundamental constitutional flaw in General Preligar's argument.
If Congress can expressly vest an agency with authority to interpret the law through an express delegation, then it can do the same thing implicitly, especially in a world where Congress has to provide the agency with the express authority to carry the statute into operation with the force and effect of law.
General Preligar's straw man doesn't show Congress vesting authority to interpret the law, but to apply the law. In her argument, Congress gives the administrator authority to define the term stationary source, not to interpret the law whichever way they want. To make matters worse, General Preligar claims that when Congress does not tell an agency they can do something, that means they have the power to do it. This not only violates the plain language of the Constitution, but places the executive agencies above the very Congress that created it. After all, if any agency can interpret for itself what the law means, their word becomes law. Only after those harmed by such totalitarian rule have spent years and untold dollars pursuing a court case can they expect any sort of redress of grievance for those agencies' actions. And then only if the court finds the agency's interpretations unreasonable. A very fickle standard indeed. Should Congress draft new legislation to restore its intent to the law, we once again would have a long and fraught process, one that does not guarantee the original intent of the law is applied. Now, after each attorney presented their case, the justices had a chance to ask them questions. Justice Sotomayor asked Mr. Clement,
it seems like most people agree if the statute uses reasonable, that Congress is delegating the definition of reasonable to the agency. And the agency is deciding what is reasonable within some outer limit either set within the statute or within the law. But the point is that it's great rhetoric, Mr. Clement, but we do delegate. We have recognized delegations to agencies from the beginning of the founding of interpretation. And so I'm at a loss to understand where the argument comes from.
See, here we see Justice Sotomayor using the same sleight of hand that General Prelogar did. Petitioners are not questioning the agency's definition of reasonableness, but their actions without any statutory language. Remember, the law did not give discretion to the Department of Commerce when it comes to who pays the salary for the monitors. It was silent on the subject. Justice Kagan asked,
well, because you have no other option. I mean, what Chevron is it's a recognition that in certain cases you apply all those tools and the conclusion you come up with is Congress hasn't spoken to this issue. And if you had no other option, you're a court, there's a case before you, you try as hard as you can, even though you know you're basically on your own. But when Chevron comes in, when there is an agency, what Chevron says is now there are two possible decision makers. There's the agency and there's the court. And what we think is that Congress would have preferred the agency to resolve this question when congressional direction cannot be found because of the agency's expertise, because of the agency's experience, because the agency understands how this question fits within the statutory scheme. So it's not a question of the court couldn't do it. It's a question of once congressional direction can't be found, who does Congress want to do it?
it's not the role of the agencies or the courts to speak for Congress. If Congress did not speak, it did not speak. It's then up to Congress to decide if it wishes to speak on the matter. What Justice Kagan wants is to subvert the separation of powers and assume the role of medium in order to define what Congress wants. Even Congress doesn't think that's a good idea. Mr. Clement responded,
So, Justice Kagan, if we're going to talk about what Congress wants, we probably should at least avert to the fact that we do have an amicus brief in this case from the House in its institutional capacity. And it doesn't want Chevron. It's on our side of the case.
When the actor you're claiming to fill in the gaps for, or at least part of the actor, is telling you that you're wrong, that pretty much should seal the deal. Not for Justice Kagan, though.
If it doesn't want Chevron, it has total control over Chevron. It can reverse Chevron tomorrow with respect to any particular statute and with respect to statutes generally. And it hasn't. For 40 years, it has acceded to Chevron, except in super rare cases. It has basically said, this is the background rule. It gives us a stable default rule from which to write statutes, and we've accepted that.
Au contraire, Ms. Kagan. Chevron is not the creation of Congress, but of the very court you currently sit on. Yes, Congress could have passed a law that more tightly defines who decides ambiguities, and probably should have. But that would certainly take longer than tomorrow. And just what would keep the courts from simply reinterpreting Congress's intent in the future? Now, Mr. Clement responded,
Fundamentally, even more problematic is if you get back to that fundamental premise of Chevron, that when there's silence or ambiguity, we know the agency wanted to delegate to the agency. That is just fictional, and it's fictional in a particular way, which is it assumes that ambiguity is ours a delegation. But ambiguity is not ours a delegation, and more often what ambiguity is, I don't have enough votes in Congress to make it clear, so I'm going to leave it ambiguous. That's how we're going to get over the bicameralism and presentment hurdle. And then we'll give it to my friends in the agency, and they'll take it from here. And that ends up with the phenomenon where we have major problems in society that aren't being solved because instead of actually doing the hard work of legislation, where you have to compromise with the other side at the risk of maybe drawing a primary challenger, you rely on an executive branch friend to do what you want. And it's not hypothetical.
Again, Mr. Clement brings us back to the point. Because of congressional laziness, even dereliction of duty, they have given up the work of actually writing complete laws, leaving the executive agencies to fill in the gaps in their legislation. While that may be the fundamental intent in some cases, it is a violation of the Constitution of the United States. By deferring all decisions to the agencies, the courts too had violated their oaths to support the Constitution. As Justice Thomas asked General Preligar,
how do we discern delegation from statutory silence?
So, Justice Thomas, I think that it would be wrong to suggest that you can neatly categorize cases as those involving silence and those involving ambiguity. And the reason for that, I recognize that Chevron itself used both of those terms, but I think that the court was just trying to be comprehensive about those kinds of circumstances where Congress hasn't itself directly resolved an issue.
did you catch the switcheroo? Justice Thomas asked General Preligar how to tell the difference between delegation and silence, and she switched it to silence and ambiguity. Justice Thomas's question has a very simple answer. Delegation is a positive statement, such as defined by the administrator. Silence is the absence of a statement. Now, the entire issue of both this case and Chevron comes down to a single question. Is governmental power positively or negatively defined? Does a government actor have to have a positive statement that he can do something, or are they free to act unless there is a specific prohibition? When it comes to the federal government, the answer should be clear. From the 10th Amendment, we read, "The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. The United States only has the powers delegated to it by the Constitution. Since, as Article 1, Section 1 of the Constitution states, all legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and House of Representatives. All power for making law, legislative powers, is vested in Congress, and only Congress. They do not have the power to delegate lawmaking power to executive agencies. And since Article 3 only delegates to the courts the judicial power and the powers to decide controversies, they do not have the power to fill in the gaps, as General Preligar claims. Chevron appears to have been an attempt to keep things going when Congress was silent or ambiguous on a specific issue. If Congress leaves gaps in their legislation, it's up to Congress, the representatives of the people and the states, to fill them in. It's most certainly not within the powers delegated to the executive or judicial branches. We'll have to wait and see if a majority of the justices on the court recognize the usurpation of powers Chevron deference has become. During my research for this episode, I found it interesting that the Chevron deference was originally thought as a ability to restrain the executive agencies, because it came up in a case where President Reagan wanted the agencies to decrease the power of the agencies. Sadly, as I said, you give an agency an inch, they take a mile. Now they simply make stuff up out of thin air. Well, the law didn't say we couldn't, and that's how you get away from self-rule. That's how you get away from a republic to an oligarchy. If unelected bureaucrats can effectively make up laws, where does that leave a government of, by, and for the people? Now, Chevron has been a problem for many years, for decades, and it's been a problem that Congress has been unwilling or unable to deal with. The question is, will the Supreme Court? I don't know. I try not to prognosticate too much because you never really know how people are going to decide in a case like this. But we can keep an eye on it, and we'll do that here at the Constitution Study. Because it really comes down to a fundamental question. Can the agencies do whatever they want unless Congress says no? Or once Congress opens a door, are the agencies free to rule however they wish unless Congress specifically says no? Since in this country it is the government that has the burden of proof, I would rule against Chevron. But then again, I'm not on the Supreme Court. Now, if you want to keep up on this, well, check out the website, constitutionstudy.com. I will cover the decision when it's made, probably not until June. Of course, you can always sign up for the mailing list and have my articles and videos sent to you as soon as they're published. And then, well, you'll know as soon as I publish it what the court does with this decision. There's other lists you can sign up for. You can donate to the cause. You can join the Patriots program. It's all there on the website, constitutionstudy.com. By the way, if you're watching this as a video on YouTube, please check out Rumble. YouTube's been doing some weird things lately with some of my comments, and I'm concerned things may be getting a little wonky. Whereas Rumble, I've had no problem with them. Just go to rumble.com and search for the Constitution Study. You'll find my channel. Everything I post here, I post there as well, so you won't be missing anything. Most of all, I hope you found this interesting enough that you want to find out more. You'll check out the website, maybe ask a question while you're there. Most importantly, I hope you come back and join us here next time for the Constitution Study.
Love the neighbors and have a few good friends.